self-determined instead of patronized in old age. Avoid a guardianship or obstacles to action. In the event of your own incapacity, you decide now who may act on your behalf in the future and carry out your business. An advance directive drawn up in good time can help. In this video, you will learn how to compile one and what needs to be arranged. My name is Tamara Freiner. I am an independent attorney at law in the canton of Zurich. If this video appeals to you, please like and share it. Who will act on your behalf if you become incapacitated? You could have an accident, or be seriously ill, or simply be of old age. Who will pay your outstanding bills, for example? Who will manage your assets? Or who will file your tax return? Or do you think this doesn't affect you at all? Your spouse or partner can act on your behalf in any case. Really? People who are not married have no legal right of representation. Even in the case of not separated spouses, such a right only exists for everyday transactions, not for land registry or mortgage transactions. Who can establish an advance directive or a healthcare proxy? A person who is capable of acting, for instance, of legal age and capable of judgment. You need to describe this task to be assigned for personal care, such as personal affairs, for asset management, such as financial matters, and for representation in legal dealings before authorities, courts, and companies. You may issue detailed instructions to fulfill the tasks. So who may you trust? Only appoint reliable, clearly identifiable trusted persons. Clarify in advance whether the person is willing to accept this assignment. Appoint substitute representatives in the event of non-acceptance or termination of the assignment, unsuitability, or conflicts of interest. The appointed person of trust, so-called advance directive representative, has an obligation of discretion and a duty of care. They will fulfill the mandate personally without permanent supervision, except demanding an account. They are appropriately remunerated and their expenses are reimbursed. To draw up an advance directive, you need to fulfill certain formal requirements. So do it by writing by your own hand from beginning to end, date it and sign it. A pre-printed form is insufficient. Only a healthcare proxy that has been established in the correct form and can be found is of any use. Its existence and place of deposit can be registered at the relevant civil registry office. You can revoke your advance care directive at any time before it's validated. However, you must revoke it in a form that is prescribed for its creation. The original of your advance directive or healthcare proxy must be submitted to the Child and Adult Protection Authority for validation. The authority checks whether you are incapacitated, whether the advance care directive is formally valid, and whether the appointee is suitable and willing to carry out the tasks. After validation, your advance care directive is effective for an unlimited period of time. It loses its effect by law when the principal regains his or her capacity of judgment. So you certainly ask yourself, when should an advance directive be drawn up? From the age of majority, as soon as possible. Seek advice. If there is no healthcare proxy, or one exists but has not validly been established, the Adult Protection Authority must examine measures under Adult Protection Law. Please make a note of who may be qualified as representative and what tasks need to be assigned. For more information, please do not hesitate to contact me. And also follow me on social media in order not to miss any news or insights.